Hello everyone and welcome to our third video tutorial on the criminal process. In our first video, we looked at the three categories of criminal offence, the criminal court hierarchy and the criminal appeals process. In our second video, we were looking at the role of the CPS, and in today's tutorial, we'll be looking at bail. Again, this is another little recap for you, because if you remember, we studied this topic very early on in the course when we did criminal law. It's part of the rules and theory of criminal law topic. So bail can appear on two exams. It can appear as a criminal rules and theory question on exam 3, but for us at the moment, we are looking at exam 1, section B. Bail could come up as a 10 and or a 15-mark question on that section. Being given bail simply means that the person's allowed to be at liberty until the next stage in the case. So obviously we don't want to charge a person and then lock them up until trial, because the trial might be a long way in the future. So at this point, it might be useful for you to just pause this video and see if you can remember, maybe note down all the different reasons why bail is important. Okay, hopefully you've come up with some ideas then. Bullet pointed some of the key reasons why bail is so important on this slide for you. Firstly, it's in line with Article 5 of the European Convention on Human Rights, right to liberty. And remember that a person is innocent until proven guilty. So until that court of law has found them guilty, they are innocent, and therefore we don't want to be locking them up, depriving them of liberty until that point. Home Office data suggests that 20% of those in our prisons awaiting trial go on to be found innocent or given non-custodial sentences. So if you're thinking that we're keeping people in prison and then they're later going to be found innocent, that would be an unfortunate situation, so bail is the better option. And bail also allows the suspect to carry on with family life, to carry on with their work until the trial. And it also helps them, I suppose, with Article 6, right to a fair trial, because it enables the suspect to have some time to prepare his or her case. And also, you've got to remember that prison populations are very high. There's obviously a reduced cost to the government if we can bail people and we're not keeping them in prison up until their trial. So there are two types of bail. It can be given by the police and it can also be given by the courts. There are three situations here where the police might grant bail. So they might grant bail to a suspect who they've released without charge, but they've said that they want them to return to the police station on a specific date in the future, and that's under the Police and Criminal Evidence Act 1984, section 37. Notice though, and there's a big change that's come in here, that if they've not charged the person, they can now only be on bail for 28 days, no longer than that. Because previously there was a problem with people who hadn't been charged, so presumably not enough evidence to charge them, languishing on bail for a long, long period of time. So that's not going to happen now because of the Policing and Crime Act. So that's to people who haven't been charged. Police could also grant bail to a defendant who has been charged with an offence, and in that case the person will be bailed until the early administrative hearing at the Magistrates' Court. And you can see here that the custody officer who's in charge of bail can refuse bail if the suspect's name and address can't be discovered, so they might be refusing to give it, or there might be a suspicion that the name and address isn't correct if they're being told it's Mickey Mouse from Disneyland, for instance. Another situation where the police can grant bail would be, it's sort of called street bail, and this is for minor offences, and there's no need to take them to the police station for this. Courts also have power to grant bail, and the courts will review any decision of the police to refuse bail. The court's powers to grant bail are governed by the Bail Act 1976, and Section 4 of this Act is very important. It gives a presumption in favour of bail, And that means there's a general right to bail, meaning usually you get bail, but this can be rebutted in certain circumstances. So usually you'll get bail, but we can take that general rule away if certain circumstances apply. Notice we've had a change though in 2012. LASPO says that there's now a no real prospect test. So it says that the starting point for court bail is that bail must be given if there's no real prospect that the defendant will be sentenced to a custodial sentence. So as well as a general right to bail, we're also saying that if they're not going to get a custodial sentence, then you've got to be giving bail, because it doesn't make sense to lock them up before a trial knowing that even if they're found guilty, they're not going to be going to prison. When deciding whether to grant bail or not, the court looks at a number of factors, and these factors are listed in Bail Act Schedule 1, subsection 9. And these are pretty common sense when you look at them. So the court's going to consider the nature and the seriousness of the offence, the character and the past record of the defendant, any community ties they have, their record of surrendering to bail. So that means if they've ever been given bail before, did they comply with it? Did they turn up at court when they were supposed to? And the court will also consider the strength of evidence against the defendant as well. And it's kind of like a balance, a weighing up of all of these different factors. And once the court has considered those factors, it also considers whether there are any reasons for actually refusing bail. So remember, under Section 4 of the Bail Act, they're starting with the presumption that you'll get bail, but it can be refused if there are substantial grounds, and that's important. Substantial grounds for believing one of these things might apply. So, is there substantial grounds to think they're going to commit another offence while on bail? Is there a chance they're going to fail to surrender? So, do we have substantial grounds for believing they might do a runner, go off to Spain or somewhere? Are they going to interfere with witnesses or obstruct justice? You know, are they a member of the mafia and we think they're going to interfere and start threatening our witnesses? We've now got a fairly new reason for refusing bail, and that's where the court thinks the defendant's going to commit an offence against an associated person in a domestic violence case. So if they're being charged with domestic violence, is there a risk that if we grant them bail, they're going to go straight back to that victim and inflict worse harm on them? And the final situation is that the suspect needs to be kept in custody for their own protection. And that might sound a bit unusual or a bit strange, but if you think about cases that have had high media attention, there is a chance that suspects, even before they've had a trial, they might be attacked by members of the public. So it might be that they need to be kept in custody for their own protection. As well as those general reasons for refusing bail, we also have other restrictions, and these are like some special extras, if you like, for particular situations. So under LASPO, if a person has previously served a custodial sentence for murder, manslaughter or rape, and the current offence that they've been charged with is murder, manslaughter or rape, the judge can only grant bail if there are no exceptional circumstances. Terrorism is also one of these special cases. So all bail applications from suspected international terrorists are actually dealt with a special commission, the Special Immigrations Appeals Commission, not a normal court. So they'll review terrorism cases. If your defendant was already on bail at the time that they've committed this new offence, then bail's going to be refused unless the court's satisfied that there's no significant risk they'll commit another. So if they've committed an offence whilst on bail, that might be a fairly good reason why you're going to restrict it on this occasion. and that comes from the Criminal Justice Act. And the final special situation for refusing is involving Class A drugs. And if our defendant or our suspect is tested positive for a Class A where the offence is connected to Class A, we can refuse bail in that situation. Now, because we've got a general presumption in favour of bail and a reluctance to refuse it or to restrict it, it might be preferable, rather than refusing bail altogether, to put conditions on bail. So to grant it, but add some conditions that the suspect has to comply with. And under the Criminal Justice and Public Order Act 1994, the police and the courts can give you bail, but they can add conditions. So there's some examples here. So someone might be bailed, but they might have to have a curfew. And curfews often go hand in hand with an electronic tag. So if the person is suspected of committing lots of crimes at night, it might be logical to say, right, you can have bail, but you have to be at home by 6 p.m. every evening. And the tag is a way of ensuring that they comply with that. A surety, slightly more unusual, that is where you ask perhaps a mum or a loved one to offer a surety, a sum of money, if the person doesn't attend at court. And that can encourage the suspect to surrender to bail as they are supposed to. If there's a concern that maybe they'll do a runner, that they won't turn up at the trial, it is possible to grant bail but ask them to surrender their passport. And obviously that limits where they can go, so they wouldn't be able to do a bunk to Spain. And you could also get them to report regularly to a police station. So you might say, well, you can have bail, but you have to come back to this police station at 12 p.m. every day. And if you do that, that obviously limits how far your suspect can go in a day, because obviously they have to be back for that reporting. There are bail hostels as well, so people can be required to reside at a bail hostel. That's another option. And I've got some quite interesting case examples here of people who were given conditional bail. And Ryan Cleary is the one that's most interesting to me. He was charged with attempting to hack the website of the Serious Organised Crime Agency, and he was given conditional bail. And it was quite extensive, so he had to have a curfew between 9 p.m. and 7 a.m. every night. He had to wear a tag. He was only allowed to leave the house with the company of his parents. He had to live and sleep at his home address, have absolutely no access to the internet, and have no devices capable of using the internet. Think about that for a second. How would you lot cope for 5 minutes without your phones? So that just illustrates how flexible conditional bail can be, and it can achieve the aim of giving bail, but still ensuring public safety and that they're not reoffending the similar. Now, a very common bail question that you could be asked is about balancing interests. And this is a very popular 15-mark question where you might get asked to analyse and evaluate whether bail adequately balances protecting the public with the rights of the defendant. Because if you think about bail, on the one hand, we want to protect the public from a potentially dangerous suspect. But on the other hand, we know that a defendant is innocent until proven guilty, and we want to respect their individual rights also. So this is a question that is well worth spending some time planning. And there are some arguments that you could put into that essay. And I've framed them as advantages and disadvantages of bail, but you could rework them into a balanced question. So it might be worth just pausing the video at this point and having a closer look at those. But really, hopefully, bail does strike a balance. And ideally, if you give conditional bail, that is striking a balance between the two, because we are protecting the public and we are respecting the rights of the defendant.